I was in the Army until active duty until 2016. I've been a nurse my whole life. I can't have these charges and actually be that. I've been on disability, permanent disability.
Ms. Hazlitt, you need to answer the question I asked.
You asked what I do, and that's what I do, sir.
What do you do for a living?
I'm a nurse. There you go. Combat medic. Cable communications.
You're a combat medic here in Porter County?
No, sir.
So what do you do for work now, Ms. Hazlitt? Do you earn
I'm
any
on
money?
permanent disability through the military.
Okay. How much do you get from the VA?
$15.27 a month.
We're cool. Let's go.
Carleen Hazlitt, state, would you please set a record?
Yes, Your Honor, thank you. This is State of Indiana versus Carleen Hazlitt. The cause number is 64D012602F62086. Defendant appears in court in person by video conferencing. She is here with Mr. Annette Henson of the Public Defender's Office for our Criminal Rule 2.6 purposes. State of Indiana by Gary Gurman.
Morning, Ms. Hazlitt.
Morning.
Can you hear us okay?
Yes, I can.
First, I'm required to advise you of your various rights in this matter. You have the right to hire an attorney to represent you. You have the right to have an attorney appointed to represent you if you cannot afford an attorney. You have the right to a public and speedy trial by jury, and you have the right against self-incrimination. That means you could not be forced to make any statement or testify against yourself at any hearing or trial held in this matter. Do you understand those rights as I've just gone through them?
Yes, sir.
A former Army combat medic and lifelong nurse is now facing a felony charge for allegedly threatening to kill 3 people. What starts as a routine court hearing quickly turns chaotic when the judge can't get a straight answer to a simple question. With intimidation charges, domestic battery allegations, and growing courtroom tension, this case takes some unexpected turns.
Count 1, intimidation, a level 6 felony. The cause states that on February 24th, 2026, in Porter County, you did knowingly or intentionally communicate a threat to a Christopher Quall with the intent that he be placed in fear that the threat would be carried out. And they allege that you remarked that you would kill Christopher Quall and 2 other witnesses on scene, and that the threat was to commit a forcible felony. Do you understand the allegations in count 1?
I understand them.
And it's charged as a level 6 felony, which carries a possible sentence of 6 months to 2.5 years in prison and up to a $10,000 fine. You understand that possible penalty?
I do. Count
2 alleges domestic battery, a Class A misdemeanor. It states that on February 24th, 2026, at 1355 Camelot Manor in Porter County, you did touch another person, Christopher Quall, in a rude, insolent, or angry manner by slapping him with an open hand.
Yes, sir.
I was just seeing if there was more, ma'am. Do you understand the allegations in count 2?
Yes, I do.
And a Class A misdemeanor carries a possible sentence of up to a year in jail and up to a $5,000 fine. Do you understand that possible penalty?
Yes, sir.
As required by statute, the court will enter a preliminary plea of not guilty for you on counts 1 and 2. Do you plan to hire counsel?
No, I'd like a public defender, please.
Okay, please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
I do.
Okay, thank you. And what do you do for a living?
So I got out of the Army about a year ago. I was in the Army until active duty until 2016. I've been a nurse my whole life. I can't have these charges and actually be that. I've been on disability, permanent disability.
Ms. Hazlitt, you need to answer the question I asked.
You asked what I do, and that's what I do, sir.
What do you do for a living?
I'm a nurse. There you go. Combat medic. Cable.
The judge is asking a simple question: what do you do for a living? But instead of a direct answer, the conversation keeps going in circles. Every response seems to create more confusion, and you can already see the judge's patience wearing thin. Sometimes in court, clear answers matter just as much as the evidence itself.
Cable communications.
You're a combat medic here in Porter County?
No, sir. I got
Okay, so what do you do
Army.
for work now, Miss Hazlitt? Do you earn
I'm
any
on
money?
permanent disability through the military.
Okay. How much do you get from the VA?
$15.27 a month.
1527.
Yes, sir.
And do you have any other source of income?
No, sir.
Do you have any kids?
I have a lot of kids. They're all grown.
You don't have any care of any dependents?
No.
All right. Where do you live?
I've been living in Portage since September. My plan is to go back to Tucson.
Do you pay rent anywhere or a mortgage anywhere?
No, no, sir. No, because we were paying $400, but my boyfriend, my ex now, is taking care of that, so I didn't have to pay it.
Okay. And then do you have a car?
Yes, I do.
What do you have?
I have a 2019 Honda HRV that I pay $578 on.
You have a payment on it right now. It's $578.
Yes, sir.
How many more months are due?
I just got it. It's a 3-year loan.
Okay. All right. So you basically have $1,000 a month. What else do you spend your money on? If you're not paying rent, not paying utilities, anything like that, you have a car payment and that's it. What else do you have?
No, I've got my phone bill. I've got my kids' stuff. I take care of one of my daughters. She's a little handicapped, so I take care of her.
So you do have a dependent under your care?
No, I do it voluntarily, sir.
Well, she's still a dependent, it sounds like. Do you claim her on your taxes?
No, I do. I don't file taxes. I've been on disability since 2018.
Okay. Did you get any retirement or anything from the Army?
Yeah, it stopped when the government shutdown came through.
Any lump sum buyout or anything where there's any money still left in savings?
No, sir.
Any other big ticket property items besides the HRV?
No, sir.
I'll find you're indigent, you qualify for the services of the public defender. I'll appoint the Porter County Public Defender Service to represent you. It's close on this one, but I think you're there. Mr. Nat Henson's here from that office to help me make some decisions about your release from jail, any conditions related to that release.
Your Honor, in speaking with Mr.
After reviewing her disability income, expenses, and financial situation, the judge makes an important decision. He admits it's a close call, but ultimately finds that she qualifies for a public defender. For someone facing a felony charge, that ruling could have a major impact on what happens next.
Mr. Gurman, I believe there's an agreement to release the defendant on her own recognizance.
Okay. State?
I agree, Your Honor.
Okay. So we want to do the recommended level 1 supervision?
Yes, Your Honor.
No bond?
No bond. I'm willing to agree, Your Honor.
Okay. This one suggests that she should have a small bond, but let me see what I said. Is there any amount of bond you can afford, Ms. Hazlitt?
No, sir. And he put his hands on me and didn't get arrested. So I
Miss Hazlitt, just answer. Miss Hazlitt, just answer the question.
No,
Is there a
I
bond you can afford?
cannot.
Okay.
Okay. Thank you, Mr. Henson. Yeah, well, I mean, if the state's willing to go with the OR, I'll give you an OR release. I know. She got some priors, state?
None that I see, Your Honor.
Okay. So I'll find that you're a danger to the community. Actually, I'm going to find otherwise. I'll find that you present a substantial risk of failure to appear.
Just when release seems likely, another issue appears. The defendant admits she doesn't have a confirmed address and plans to leave the area. That's a major concern for any judge deciding whether someone will return to court. Suddenly, the focus shifts from the charges to the risk of failing to appear.
Risk of failure to appear. And that's because I'm not sure you have any place to live, and you told me that you plan to go to Tucson.
Can I prove that I have a place to go?
I need to have just a minute before I get back to that question, but
Okay.
I'll find there's clear and convincing evidence you present a substantial risk for failure to appear nor need of supervision. I'll place you on pretrial supervision, level 2 supervision. I'll show that you have no criminal conviction, no prior record of criminal conviction. I'll assess no fees. You will be required to appear as directed by your pretrial services officer. Notify them of any change in address, phone, or email. Let me just see this. Yeah, what did you ask me?
I asked if I was gonna get out on my own or cognizant if I needed to provide where I'm gonna be living.
Yeah, do you have an address?
I do not. I know that Troy Simmons and his dad and Becky Simmons live in Evansville, and they said that if I have any problems, I can go there, but that's out of Porter County.
All right, so you're gonna have to figure that out by the end of the day. I'm gonna let you out your own cognizance, but there's gonna be a requirement that you go to the probation department at 157 Franklin Street and get started on the terms of your pretrial release. One of the things they're gonna require from you is your address, any updated address. So that's gonna be critical for your supervision here. I just want you to be very clear on that. There was a no contact order entered in the case. I don't see that I signed that yet. So that's also going to be required before you're able to be released from jail. I'll sign off on this no contact order. You're not to have any contact with Mr. Quall. And if you have any contact with him, you can be charged with invasion of privacy. That would be a Class A misdemeanor, which could carry a possible sentence of up to a year in jail and up to a $5,000 fine. Ms. Haslett.
Was that permanent or 10 days? I was told it was 10 days.
It's permanent until further order of court is how I'm going to sign it. There was a 10-day in place, but that'll be taken off. And I'll sign this permanent one that will last until I take it off.
Sweet.
And I'll set you up for a couple hearings. The first one's called an omnibus hearing. That'll be on April the 17th at 9 a.m. The second one's called a pretrial conference. That'll be on June the 5th at 9 a.m. You're ordered to appear for both of those hearings. And we'll see you back here then.
All right.
In the end, the defendant is released without posting bond, but strict conditions come with that freedom. She must follow supervision rules and obey a permanent no-contact order. One mistake could lead to even more charges. What do you think? Was the judge too lenient or completely fair?